thank you. Good morning, everyone. Welcome to the second day of our inquiry session into the planning appeal at Airthrey Kerse. My name's David Little, the reporter appointed to this case. I'll not go through the formalities of yesterday. It's all the same people. I don't think we need to do that. So just before we start, there were a couple of things. I've got the English court case, which you referred to, Mr. Findlay, yesterday in connection with Glavin 2020, I think it was. I've also got the committee report that was, which I already have, but it's now got a document, a core document number, so that's fine. We can be referred to as needed today. And the other thing I recall, Mr. Findlay, you were going to take a view on the late documents submitted by the council. I don't know if you had a chance to consider that point.
Yes, no, I'm happy for the late documents to be admitted.
Okay, thank you for that. Okay, so we were nearing the end, or in the latter stages at least, of cross-examination. So I'll just pass back to you, Mr. McMurray, to continue where we left last night.
Thank you, sir. Good morning, Mr. Phillips. You may be on.
Good morning. Thank you.
Okay. Where we left off yesterday, I think we were starting to have a look at Mr. Laird's suggested programming or estimated programming for the approved site, which is an SC1 and table 4.1. And perhaps maybe useful if we could have also core document 33. It's table A1 in there, which I believe is Helen's anticipated phasing.
Yes.
As I read these two programs, there's a huge amount of difference between yourself and Mr. Laird, certainly in respect of post-grant planning permission. Is that, say that's fair?
I think there is a difference between the two, because the phasing for the 5-year period for Knight Laird is 30 homes. We are 174 homes within the next 5 years, and the completion numbers for those years are different. So there is a difference, as well as in the lead-in period.
But perhaps we just look at that in a bit more detail in terms of onto maybe the pre-grant planning permission period in a moment, but just taking it from the grant planning permission, as my calculations are that Mr. Laird is suggesting that 30 homes would be delivered in around 39 to 40 months after the grant planning permission. And I believe you suggested that same 30 homes would be granted in around 33 months, so maybe about a 6-month difference.
My calculations are from the grant of planning permission in principle, assuming to be the mid-2022. It would still be 174 homes within the next 5-year period. It'd be 100, depending on the rate of completion for each year. And I mean, I think it's important to focus on the the amount of housing within the next 5-year period, how the rate of housing in each year is of lesser relevance in terms of addressing the 5-year housing land supply issue, if you see what I mean. So it's really the critical number is the number you reach at the end of that 5-year period, which we consider is 174, 175. And that's in the context of, I'm sure we'll go on to it, the previous appeal decisions, but also our phasing that we put forward in the previous appeal, which was core document 25. Which I think hopefully is set out in the previous appeal decision report, CD22, at paragraph 3.33. And I think, because I think it's important just to understand the context of how we are where we are, and what's the phasing that's been considered previously, and what the position of the previous reporter was, or reporters. And I think that puts our numbers into a bit of context as well. Sorry to take you to a few different documents there, but I think the reporter's report, the most recent reporter's report, which is core document 22, paragraph 3.33, helpfully sets out the appellant's position at that time of the phasing for the first 5 years, reaching a total of 300. And as we know, the reporter took a more cautious approach, which is set out on page 48, concluding at paragraph 3.101. So I'll just wait for you there.
That was Phillips.
Fine, good, thank you. So the applicant in the previous appeal was suggesting 300 units within the 5-year period, but the reporter concluded that a more realistic estimate of completions over the next 5 years would be somewhere in the order of 175 homes. And effectively, the reporter pushed the lead-in period out by 1 year, resulting in year 3 being 0, year 4 being 50 homes, and year 5 being 125, making a total of 175 homes. And that number also reflected in the first appeal decision of 1752. So that's relevant for 2 purposes. One is the figure of 175 seems to be an agreed position with the reporter. Secondly, there is an agreement that the actual build rates in each year could be as much as 50 in the first year of construction, 125 in the second year of construction. So I think we need to bear that in mind in reviewing our figures that are currently set out in the first document that you suggested, CD33. And the other point, the third point I'd make at this point, which I think is useful context, is that the procedure notice that was sent out in December 2020, the reporter asked for comments from both the council and the appellant on phasing. I think that was matter 2.3. The appellant responded with the document that you first referred to at CD33. The council's response, set out in document CD30, was, and it's a very short sentence, it says, in relation to matter 2.3, it is described as 2C by the council, it says this is a matter for the appellant. And after we'd made our submission to that procedure notice, there was an opportunity for the council to come back on our phasing and completions, 5-year completions. Yet the council, in responding to the responses of the procedure notice in February 2021 in CD 34, said nothing. It's only in December 2021 does Mark Laird or the council make any comment on what were fairly undisputed position of the appellant and the reporter, and the reporters, sorry, in previous appeals. So we've got to a position where, you know, the phasing of 175, how you arrive at it, obviously there's a different approach to that, but how you arrive at it, 175 units within the 5-year period is hasn't been challenged before, and it's actually been supported by 2 reporters. So the point I was making is that our phasing in January of 36 in year 3, 48 in year 4, and 60 in year 5, I mean, that's a fairly conservative estimate in terms of build rates, achieving the 174 total. Our previous rates of 50 and 125 set out in the previous appeal shows that if necessary, those build rates in each year could be increased to a maximum of 125, I would expect, on a site like this, with 2 house builders involved. And that could, you know, if there was a concern over the lead-in period, which I think the council are concerned about, you could still achieve 175 units within the 5-year period. And that is the critical number for the purposes of this appeal and housing land supply issues. And the first reporter, I'm sorry to go on, but the first reporter in CD 21, in the reporter's report, at paragraph 2.30, in talking about phasing and completions, this is only 1 paragraph in this report. And if I could just highlight that, however, this is just quote, however, with a lead time of more than a year to deal with the matters subject to planning condition and construct the essential infrastructure, I estimate a maximum of 175 houses would contribute to the current shortage in the 5 years supply of land. And then interestingly, he goes on to say that I accept that with favourable market conditions, the build rate could be higher with 2 house building companies involved, but at the same time, it might take longer to get infrastructure matters resolved. So there was I read that saying, yes, you could achieve 175, but the build rate in each year could be higher. But so we've taken not only a conservative approach, we've taken an ultra conservative approach, because essentially you could go higher than 125. But I think where we sit is that however way you cut it, you could still achieve 175 completions within the 5-year period, whether you start in year 3 or year 4. So that provides some cushion if there was concerns about Section 75 completions and the like, really, in the context that this hasn't been challenged before by the council.
Mr. Phillips, just so I understand it, the evidence that the appellants submitted to this inquiry was that in the first year 30 units, second year 60 units, so you didn't telling us that that's that's different, or is that still your evidence?
The response to the procedure notice sets out 30 units, year 3, 60 and 84. What I'm saying is that as my text says in that submission CD33 at paragraph 1.3, it says it provides a realistic estimate that within the next 5 years 174 new homes could be built. So it's an illustration how 174 homes could be achieved in the next 5 years. And when I say realistic estimate, I mean, I think, you know, if you have a conservative estimate, then that's likely to be more realistic than anything else. So I think that phasing achieves a realistic estimate, but what I'm saying is that it's conservative. And if you look back at our previous rates of phasing in the second appeal, it shows that we could achieve 50 units in the first year of construction if it was year 4, and 125 units in the 5th year of construction, which is supported by the reporter, which is, as I say, which is likely to involve a second house builder. I would add that to that. So does that help understand the difference between, or clarification of what the phasing rate is in our current evidence in the context of previous submissions?
Well, thanks for the answer. Mr. Laird had simply relied in terms of phasing on the rate of completion that had been set out by yourself and clients in their submission. So I could go back to the point I was initially trying to focus on was actually the point when completions would start to be delivered and the lead-in time.
Yeah.
So the point I was trying to say, there's not a huge amount of difference between yourself and Mr. Laird. I think we're looking at a period of around 6 months.
In terms of the lead-in period, I've calculated it to be, you know, based on the.
I know just valuation.
Sorry, I think Mark Laird's evidence says that the first year of completions would start in mid-2025, whereas my calculation would be a year earlier than that, in mid-2024, based on the notice of initiation being issued in mid-2022. And then 3 months for the Section 75 matters, and that's set out in my my latest submission, the latest submission in the precognition, that's set out there for 3 months. Right, it's got it here somewhere. There it is. In section 6 of my precognition, completing the section in 0 to 3 months, and then the MSc approval is 12 months, but that's 0 to 12 months in terms of the start, you know, the sort of the start 0, because there's an overlap in terms of preparation. And then site enabling technical approvals, effectively that's 0 to 24 months, because, you know, as I said yesterday, some of the licensing applications, car license, RCC, could start to be prepared and submitted within the first year, really, and then enabling works could start in that second year, and then then it would be a start on site in mid-2024. So that's taking up the first 2 years, and then delivering 30 homes for occupation within that third year. But as I understand Mark Laird's evidence, he was saying that the first 30 homes would be delivered in the year mid-2025 to mid-2026. That would be when the first 30 homes would be delivered. But as I say, I mean, if it was year 4, then I've explained that there's still 175 homes, 174, 175 homes could be delivered within those first 5 years. And I just want to sort of highlight also that in policy 2.1, it does say that the hurdle for an unallocated site coming forwards was 30 units as being a reasonable contribution to the overall identified shortfall, and that would match very neatly to what Mark Laird is saying in his evidence at the moment. But having said that, we can provide a higher completions within the first 5 years. And the other point that the first reporter said on that, because I think it is relevant too. Remember, he was the reporter that said 175 houses, and it could be higher with 2 house building companies. But paragraph 2.31 of that report, this is the first reporter's report, CD 20. Sorry, the Scottish Minister's letter is CD 21. So CD 20. He says in the paragraph that follows, he says the proposed development, he's already said it would be 175 houses in the first 5 years, offers a substantial contribution to housing, land supply and infrastructure. So we have the policy saying 30 is reasonable. We have we're saying 175 houses, and we have a reporter saying that 175 is a substantial contribution to the housing land supply position. So, you know, we certainly are exceeding not only the 30 gateway in policy 2.1 number of units, but we're going beyond what would be considered a reasonable contribution. And saying there are different approaches to the way that 175 unit is reached. And I've provided a conservative estimate in the January submission, which is the one you took me to first, of 30, 60, 84.
Maybe it might help if we actually break it down step by step as opposed to across the 2 programmes. That might help us actually just see where the differences actually are. Mr. Laird is actually, he's provided for an extra stage. It's not in your programme for a start, which is the time period taken for the reporter to issue his report, and assuming the Minister and likely to grant issue a notice of intention, which he has at 6 months.
Yeah, in the table, we have 4.1. Yeah. Mark Laird's table, 4.1.
I think you'd said mid 2022 for that, so not too dissimilar.
Yeah, from now.
Actually, I think we just agree that Mr. Laird's been more than reasonable in that case, given the often timescales that take for a reporter's report and notice of intention.
I think there's agreement. I mean, I think that's the case, that in mid 2022, you know, if it was to be a notice of intention, that's the indication of when Scottish ministers might issue their decision as an estimate, as a good estimate. And so, yeah, that. Sorry, did you hear?
I didn't catch the last bit. Sorry, I thought you'd finished now.
Yes, that's fine. Yeah, that's right. So it's yeah, we seem to be saying the same thing now.
Yeah,
Year 1, 6 months.
The next stage is the conclusion of Section 75, issue of planning permission. Mr. Laird, I don't intend to go over what we discussed yesterday, but he's obviously suggested 9 months, and you've suggested 3 months for that.
Yes, and I did accept that was challenging.
So that would take us to, on Mr. Laird's timetable, around 15 months for issuing planning permission.
Yeah, that's right. On his Appendix A table, it takes us to the end of Q1 2023, whereas mine would take us to the end of Q3 2022.
Again, those timescales, they're potentially, certainly in terms of potential for further procedure. For example, a national planning framework was to be adopted in that period. There might be a requirement that the reporter might want to have further submissions on that potentially, we'd accept, but we'll
yeah, with Mark Ledd's programming, depending on parliamentary scrutiny and approval of the MPF4, it would be a matter for the reporter as to whether he asks for any further information responses on that. Although phasing hasn't been an issue before with the council, so and they haven't responded when asked before.
And then we look to the next stage. I think it's accepted by both parties that the EMSC application should be prepared at the same time as the Section 75 agreement is being negotiated. That's
yes, I think
additional time.
Well, I was a bit surprised that Mark Ledd only put preparation for MSc applications, as he described them, in the final quarter of the Section 75 negotiations on table Appendix A of his report. It just says all preparation within Q1 of 2023. I was a bit surprised that he left it so late to start preparing for the MSc. I mean, we would start when the notice of initiation had been issued. I mean, why wait?
But I think the point, Mr. Phillips, is that it's at the same time as the Section 75 agreement, and therefore we don't need to account for any additional time from where we are at the moment for that.
Well, I think I understand what you're saying. It was within the period of the Section 75 negotiations, but there's 2 months, there's 6 months, sorry, where Mark Laird is saying nothing happens whatsoever on the preparation of the MSc applications. And what I'm saying is that we would have a concentrated effort of preparing the MSc applications from the moment the notice of initiation is received, because we need to move fast and act and build on the work that we've already done. I mean, I think that would be a sensible approach for a house builder and a landowner to want to progress housing development on the site.
I don't think we take any issue with that, Mr. Phillips. That's a matter of principle for your client. I think the point Mark, Mr. Laird is, I think, trying to suggest is just that will take place during the same time as Section 75, as you suggest, and where he puts it on that time period makes no difference to the lead-in times.
Well, I think it does, because if you do more preparation work, then you will decrease the amount of work and time spent on the assessment process and the decision-making process. I mean, in my experience, if you on a site like this, you're going to have meetings with key agencies. You might need a couple of meetings with the relevant departments in the council, and so that could well take more than you want to use the time as efficiently as possible. And so I think we need to on Mark Laird's working, I think why leave it until the last 3 months of the negotiations on the Section 75 period? If you get that right when you submit the applications for reserve matters, call them reserve matters, then you should decrease the amount of time spent assessing it and determining it. I mean, it's best practice, and it's encouraged.
All I'll say to that, Mr. Hudson, both of you have 3 months for preparation of the AMSCs and your time scales. Is that correct?
Yeah, that's correct.
And if we assume that, and both timetables seem to assume you, as soon as the plan permission is granted, you submit the EMSC. I think both of you have a period of up to 6 months.
That's correct. Yeah.
Of that.
Yes.
And I think the next time period is where the difference comes in post grant planning permission, where I think we have 3 months for discharging of conditions. Mr. Laird has 6 months based on his experience of the council's workings.
Yeah, that's right. Is there's a difference there between discharging conditions. We have 3 months, and Mark Laird has 6 months. So yeah, that's certainly a difference in the estimated lead-in period. But I mean, clearly, we have a greater knowledge of the site and its intricacies than Mark Laird. So I would suggest that we are in a better position to know the issues that are likely to be relevant to the consultees at that application or discharging of condition stage, and also a good indication of what council officers will be looking for in terms of discharging the conditions that are on the planning permission in principle at that time. And we would hope that that time period could be less than 6 months, and 3 months, which is more akin to the statutory determination period for an MSc application, which I think is a matter of difference with the council too.
I think, as I understood your evidence, I suppose your suggestion is that for these matters approvals that developers are in the hands to a certain extent of third parties.
That's right. I think I said yesterday that that was a general point in terms of framing how developers might look at the phasing of development sites. And quite clearly, the developer is not the consenting authority, and there are also key agencies to consult. So it's a matter of fact that that is not all in the hands of the developer. But what I did say is that the circumstances will vary from site to site, depending on how much information has been accrued over time, how much knowledge of the site there is, and how much indication of what information is needed in order to discharge those conditions. And so I did make a distinct, and the complexity of the issues too. And I did make the distinction that Airthrey Kerse, there's an awful lot known about issues of flooding, drainage, transportation. There's been a wealth of documents that's been prepared in consultation with key agencies, SEPA, Nature Scott, Transport Department, and so we are in a very good position, and one might say a more unusual position for a developer and house builders to come forward on a site in quite a high degree of knowledge about what information is going to have to be packaged up in order to discharge the conditions, which we also know, because we're largely in agreement, I think, on these, depending on what the reporter might have to say on the matter, of course, what these condition wording is going to say, and what's going to be needed to discharge them. So it's not going to come out of the blue, these conditions, although we'd get notice of them in the notice of intention, but we have much more visibility on what they're going to say now than most developers and house builders would be. So so I think this is slightly unusual for all those reasons, that we could move quickly to package up applications that would largely, one would hope, be received in necessarily say full knowledge, but there'll be a great degree of knowledge about the acceptability or not of these things. And bearing in mind, that AMC applications are, it's a 2-month statutory period.
I think, and I understood your answer to that is that yes, there are developers are to some extent reliant on third parties. And on the next point of that, Mr. Laird is here and obviously representative of one of those third parties on which the developer is reliant, and he's giving his evidence that on his experience it would take around 6 months to discharge those approvals. Is that correct?
Could you just repeat that? Sorry, I lost.
Yeah, so you've suggested or you've accepted that developers are to some extent reliant on third parties. Mr. Laird is here as a representative of one of those third parties, saying based on his experience, 6 months would be an appropriate time for all these discharges. Is that correct?
Well, clearly, in some cases with Stirling Council, it is taking a long period of time for some applications for matters reserved by condition to be dealt with, and discharging planning conditions. Yes, there are examples where it is taking some time, and accept that Mark Laird is part of the department that would ultimately recommend and possibly determine these applications if they don't need to go to a planning panel under delegated powers, determine the applications. But as I said yesterday, this site is coming forward, we would hope, as under policy 2.1 as an unallocated site coming forward to remedy a shortfall in housing land, which one would hope that the council give some priority to in order to remedy that quickly, to avoid other sites coming forward, taking advantage of the same circumstance. It's something that they would need to deal with quickly. So we would hope that we could work in collaboration with officers, either through a processing agreement or the like, to actually deal with these discharging reserve matters and other conditions as quickly as possible, and seek to achieve support with them to deal with it either under delegated powers or at a planning panel in due course. So, while at the same time deal with technical approvals, which no doubt we'll go on to.
So I think that takes me to the point that I think in terms of Mr. Laird's programming, he's got around 25 months for all technical approvals and ready for site start, whereas I think you have 18 months.
So this is 21, 16. Is that the site? Is this pre-commencement?
Yes.
Right. So right. Okay. You're taking 6 months for the matters specified. It's got 4 to 6 months with an asterisk against it. Although I'm not sure what the asterisk is, what the asterisk means. But if you took 4 months, it would be 19 months pre-commencement. You're saying 21 months, which sounds like it's a worst case.
I'm taking 25 months.
Oh, right. Okay. Is that including?
That's 6 months for the AMSC, yes.
So 6 months. So is that 3 plus 6 plus 6 plus 6?
So it's 6 months for notice of intention.
Ah, right. Okay.
9 months for Section 75 agreement.
Yeah.
15 months. That takes us to for issuing of permission.
Yeah.
Sorry, I think my maths. 21 months to AMSC approval, then further 6 months, so it's 27 months.
27 to the end of the discharging of conditions, yeah.
Ready for site start.
Taking 6 months for the matters, the assessment of matters specified in conditions, and overlapping the preparation of AMC with the Section 75. I think that's what he's saying. Yeah.
Yeah, 25 to 27 months.
Yeah, assuming 4 to 6 months for the assessment of matters specified in conditions. So yeah, so that takes us.
Can I just
yeah.
Sorry, just because I'm the danger of confusing me here. So I just want to make sure I've understood what the 25 or 27 months proposition is. So it would be, and we're talking about from today, if you like. So it's 6 months to. The assumption would be 6 months for a notice of intention. This is what you're putting to Mr. Phillips, Mr. McMurray. So 6 months to notice of intention, a further 9 months to issue the decision following Section 75, 6 months to submit and process approval of matter specified conditions, and then a further 6 months to have discharged the conditions to a point at which you can then start on site. Is that, or sorry, that might be 4 to 6.
Yes.
There's a 4 to 6 in there somewhere. So is that I've noted that down correctly? Yeah.
Yeah, that's exactly it. So and Mr. Laird has suggested that the discharging of conditions would also run concurrently with other technical approvals, whether it be SEPA or whatever. That's included in that period.
Could I just clarify, sorry, because I think Mark Laird is saying that the assessment of matters specified in conditions runs concurrently with discharging of conditions. Well, I think there's a difference between his graphic at Appendix A and his table. Oh, hold on. No, I've read that wrong.
Well, all right. I think you're wrong.
No, I think you're right. I mean, I think it's because the discharging of conditions is concurrent with the technical approvals.
Yes, that's correct.
Yeah. So I'm not quite sure what the difference between assessment of conditions and discharging of conditions is. I'd expect those to run concurrently. I mean, the discharging of conditions, is that the decision making? That wouldn't take 6 months.
I think Mr. Laird says that it would.
Right.
I suggest you suggest that's 3 months. I'm just trying to highlight the differences between. So I think you've got 3 months, and Mr. Laird's got 6 months.
Yeah, I mean, effectively, I'm saying 9 months for the assessment and discharging of conditions of effectively the conditions submission and approval stage. And I think I've sort of combined the time period for that same process, but Mark Laird seems to be quite precise about 4 to 6 months for assessment and 6 months for discharging of conditions. Well, I'd say 6 months for discharging conditions, if that is only the decision-making process. I mean, that's a very long time to actually go through a delegated decision process or a panel process. Reporting to the panel, it would suggest that they would be deferred for some time. Maybe it's terminology. I don't know.
I think there may be a slight misunderstanding. My understanding is the reporter set out that the 4 to 6 months was the submission and determination of AMSC applications. Yeah. And the other 6 months was for discharging of other conditions which are not AMSCs. I think. Yeah.
Well, yeah, that may well be the case, and I think those could run concurrently. I don't think you need to wait to discharge other conditions that are not AMC applications. You don't have to. You can run those concurrently with applications to approve the reserve matters, if you like. So I do question that it would take 12 months to do that. I think they can be run concurrently, which would suggest that 6 months under Mark Laird's assumption would be more realistic, which actually does match probably slightly better. My assumption of 9 months. So it seems that Mark Laird is actually putting forward a swifter assessment and decision-making process than I have.
And then that just leaves the enabling works, I think, of course, is the last
Yeah, yes.
on where there's a difference. That you have a year.
Yes. Well, I have yeah, I mean, it would be in the first 2 years effectively, but it would be, you know, seen as the next 12 months on the phasing that I submitted in January, the CD33 table. Yeah, I mean, it shows a 12-month period, but effectively that 12 months could start from the issue of the notice of intention to grant, as I've said earlier, that you could submit, you know, some licenses. I mean, it wouldn't happen immediately, obviously, because work would need to be done, but you could start to submit maybe a car license or RCC application before you got to year 2, for example, of my phasing. So although I've set it as a 12-month, it's sort of 0 to 24 months, starting as 0 being the issue of the notice of intention.
If I understand it correctly, you're suggesting that your client would start the enabling works prior to the receipt of planning permission?
No, I wasn't suggesting that at all. I was saying that they could start the consenting process for some of those non-planning related works. So it wouldn't be discharging conditions. It could be things like submitting for a car license or an RCC application. Clearly, would need to be mindful of what's the prospect of getting it approved at the planning stage, because it could be a waste of time to progress something that you weren't confident that was going to get planning approval through the discharge of conditions. So I think there's a blend really to know when you feel as though you've got confidence with the scheme to submit for the car license or the RCC. But again, we do have a fair amount of information on RCC information that we could progress with. But I'm certainly not suggesting starting on site before the issue of planning permission, or indeed the discharge of relevant planning conditions. Yeah, absolutely.
Thanks for clarifying that. Just to understand, I think Mr. Laird already the technical approvals in his programming. But I think what I was trying to suggest is you've got 12 months for your enabling works, and Mr. Laird estimated it's 15 months.
Yes, yeah. I think he's got 16 months in his table, and well, I mean, it's difficult to put 16 months on a course. Yeah, so yeah.
15 months in his chart. I think it's one. Let's go with that for 3 month difference between us there.
Yeah. So I mean, if I was to comment on that, in terms of physically doing the works on site, we've indicated 12 months, and I think Mr. Laird is saying 15 months. Not a significant amount of difference, but nevertheless there's a difference. But we feel as though, given the our view of the design of infrastructure works and the enabling works on the site, and the construction of the ponds for drainage, flood alleviation purposes, as well as the key access off Airthrey Road, the roundabout access into the site. We, given our partner with McTaggart and Mickle, one of the co-appellants, who has good knowledge of developing out housing sites, that and the input we've had from engineers on the drainage scheme, we feel as though a 12-month period for site enabling works given that we've already started the consenting process for the technical aspects of those 12 months is a good estimate that's largely been accepted by previous reporters too.
Even if it was accepted, obviously your knowledge of the site, that was going to be 12 months rather than 15 months. The point I'm trying to establish that the key points of difference between, I think, you and Mr. Laird in terms of programming are the conclusion of the Section 75 agreement.
Yeah.
And then the process timescale for determination of the conditions and the technical approvals. Aside from that, you are both largely on the same page.
Well, I without having to go over the answers I've given previously, I mean, I'd rest on what answers I've given already rather than try and repeat again and misremember what I've said. So hopefully I've been clear in my answers.
Well, I think we'll all have our notes all our answers. I don't intend to spend any more time. I just wanted to establish that where the points of difference are between the two of you. If I could just turn to core document 13 again. It's a document you referred to yourself and your evidence the part I would take you through. Paragraph 2.21, possible.
Yes.
You can see this. I think this is a point that you've made in respect of some of the disputed sites. One of the findings of the research was that the completion information showed a not unexpected time lag between the grant of planning permission and principal completions on site, typically 3 years.
Oh yes, the paragraph 2.21. Yeah, as a result of the research across those local authorities, the conclusion, one of the conclusions there is set out at paragraph 2.21. And yeah, I mean, that's something I have considered. And the important point there is, I mean, the important word is typically, really. I mean, if it says typically 3 years, I mean, it's not 3 years exactly. It could be less, it could be more. But you know, the view taken on that research, it could be that.